Hello and welcome, everyone. We'll get started in just a moment. All right, thank you all for joining us today. I'm sorry, I'm getting some feedback. Thank you all for joining us today. My name is Stephanie Baez, and I am pro bono counsel for the ABA Commission on Immigration. It's my pleasure to welcome you all to today's webinar, which is the first in our three-part series called The Mechanics of Immigration Court. The focus of today's webinar is on master calendar hearings and initial filings. Parts 2 and Part 3 of this series are upcoming in late February and mid-March, and we'll post the registration links to those parts in the chat. So if anyone wants to sign up for those sessions as well, they will be available. The links will be available to you throughout the presentation today. I just have a few brief housekeeping notes before I introduce our panelists. First is that today's webinar is being recorded. And the recording will be shared with everyone who's registered. So you can watch after, or if you need to log off early, the recording will be distributed. We'll also share a PDF of the question and answers that are written into the Q&A box. So to that end, we ask that everyone, if you have questions, please put the questions in the Q&A box, not in the chat box. We have a team that will be working behind the scenes to answer questions, to provide written answers as they come in. We'll also provide time for Q&A at the end of today's presentation. But we have quite a large audience today, so we won't have time to take people off mute if you raise your hands. So please direct all of your questions to the Q&A box, and we'll do our best to answer everything. Now it's my pleasure to introduce our panelists. We are joined today by Michelle N. Mendez, who is the Director of Legal Resources and Training at the National Immigration Project of the National Lawyers Guild. Prior to joining NIP-NLG, Michelle served as the Director of Defending Vulnerable Populations Program at the Catholic Legal Immigration Network, Clinic. And at Clinic, Michelle provided training and technical support to immigration practitioners nationwide. She also engaged in federal litigation, supervised remote response projects, and oversaw Clinic's role at the CARA Pro Bono Project in Dilley, Texas. Before joining Clinic, Michelle was a senior managing attorney at Catholic Charities DC, where she began as an Equal Justice Works Fellow sponsored by DLA Piper. Michelle has quite an extensive immigration experience and background, and we're truly honored to have her join us on the panel today. Michelle is also joined by Denise Gilman, who is a clinical professor and co-director of the Immigration Clinic at the University of Texas Law School. Under Professor Gilman's supervision, students in the Immigration Clinic engage in advocacy on behalf of migrants before immigration and federal courts and the Department of Homeland Security. Professor Gilman also teaches a refugee law course. She's previously served as a director of the Immigrant and Refugee Rights Project in the Washington Lawyers Committee for Civil Rights and Urban Affairs, and has a background in international human rights law. She also serves on the ABA Commission on Immigration, for which we're very grateful. So again, thank you, Professor Gilman, for being here and sharing your expertise with us as well. So with that, I'm going to turn it over to our panelists to get the program started. And just a moment, I'm going to share my screen with you all. Just one moment. Okay, can you see the slides as it should be? Nope.
They're still in.
Okay, here we go.
Showing the setup.
How about now? Did that change?
There you go. Perfect.
Perfect.
Great.
Okay. All right. Thank you, Michelle and Denise.
No, thanks. Thanks to the organizers for putting this together. We're excited to be here today. And Michelle, you are way too flattering. We thought that it would be helpful to do this in sort of a question-answer format between Michelle and me to get the conversation going and hopefully hit on a bunch of the points that you all probably have on your minds. So I'll start right off. Michelle, how do we know that a client is in removal proceedings in immigration court in the first place?
Yeah, so when you get a potential client who comes to you, what you're going to want to do is ask for any immigration issued paperwork. And you want to look for specifically a document called the Notice to Appear, which we call the NTA in immigration law. And just be forewarned because immigration law is acronym heavy, and this is just one of many acronyms, and we apologize in advance if we don't describe what an acronym is during this conversation. But the NTA is the charging document. That is to say, the document that DHS created for the alleged non-citizen to tell that alleged non-citizen that, hey, we're placing you in removal proceedings in front of an immigration judge. Now, just because a potential client has this NTA, that doesn't mean that they're in removal proceedings, because service of an NTA itself is not going to commence proceedings. As always, you're going to want to look at the law, so you're going to look at the INA, you want to look at the regulations, and the regulations at 8 CFR 1239.1a tell us that DHS must actually file the NTA with the court to commence proceedings. Now, the next question should be, how do we know if DHS has filed that NTA with the immigration court? There's now a couple of ways to figure that out. You can call the EOIR hotline, which is a 1-800 number, which you can put in the chat for you. Or you can also go to the EOIR automated case information website, and you can plug in either one of those, the phone or the internet, the A number, which is the alien number. That's what it stands for. No, not a great name, but that's what it's called. And so the alien number, that is the alleged non-citizen's unique identification number in immigration processes. And it's comprised of 9 digits. It appears on most DHS issued and EOIR documents. Currently, my understanding is that DHS is issuing A numbers in the 220 million range. So 22X, XXX, XXX, whatever that number is. And that format is helpful to know because it indicates the time frame that the person might have been in contact with DHS or INS for that fact, right? And so the older the number, or the if the number comes before, right? So 09 XXXXXXX, that's going to tell you that that person had contact with immigration a while ago. But the current number, like I said, is going to be in the 220 million range. So that'll tell you they were recently placed in proceedings, or they were recently issued an NTA. And so once you plug in that A number on the EOIR hotline, speaking specifically about that hotline, the automated system is going to tell you that the system shows your name is, and then proceed to spell the last name followed by the first name, or that there's no record for that A number. Those are going to be your options. And so note that now that you know how to figure out if somebody is in removal proceedings, one suggestion that we have for you is that one of the first steps you take upon accepting a case, so the client goes from potential client to client, is that you file a Freedom of Information Act, or FOIA, for your client with the immigration agencies that may be relevant. That way you have a holistic understanding of what happened in that client's case, and you have all the documentation needed.
Yeah, and Michelle, and so what happens if you call the EOR hotline or you go into the automated case portal and a case does show up in the system, but it says there's no hearing date scheduled?
Yeah. So if you get a response that there is for example, the name comes up, right? So as I mentioned before, so the name comes up and it says your name is, and then it spells out the name. That means that DHS has filed the NTA with the immigration court, but the immigration court has not yet scheduled that hearing. So note that even if the NTA, at the bottom of the NTA, the time and place of the hearing is included there, the immigration court can and often does change the hearing date. And if the NTA does not include a time and place of the next hearing at the bottom of it, you're going to want to familiarize yourself sometime after this presentation with the Supreme Court decisions of Neitz-Chavez versus Garland and Padeta versus Sessions. So you're going to want to keep calling the EOIR hotline. You're going to want to keep plugging that A number into either the hotline or the EOIR case information system, the automated case information system website, to learn when is the next hearing going to be, or when is the first hearing going to be before the immigration court. You're also going to want to ensure that the court has your client's current address, since EOIR sends notices of hearings via mail. All right. So let's go on to the next question, and let's continue this conversation about, what to expect next. Like, if my client is in removal proceedings and I figured that out through the ways that we just described, how do I become admitted in immigration court so that I can subsequently enter my appearance and practice in this forum? How do we do this, Denise?
Right. Yeah. And actually, it is a good segue because the description that you just provided of how you can find out about a case status in the immigration court system, the automated portal and the 1-800 number, those are both ways that you can get access to some information in most cases, even without entering an appearance. So this is, it is good to talk about the fact that that can even be for potential clients where you're not in the case yet. There are a few cases where the courts have designated them as confidential. And so actually, it will show that there's a case in the system, but will provide you zero information about hearing dates or anything else unless and until you enter an appearance in the case. So that's just something to know as well. So, but let's say you are ready to go ahead and move forward and take on a client in removal proceedings and enter an appearance. So the first thing you have to do, and this is unique to immigration court, is that you have to enter an e-registry profile. You have to register to serve as an attorney before the immigration court. And that is a two-step process. There is an electronic registration link that you have to go to through the ECAS electronic filing system that's pretty new. And then even once you've registered there, you have to provide valid identification documents to show that you're the person who has registered. It used to be the case that you had to physically go down or to one of the local immigration courts to do that. There is now a way to do it online via video, actually. So if you are distant from the nearest immigration court, or if there are other reasons not to appear in person, you can do that via video.
Great. And so what will be my client's first hearing in immigration court?
Yeah, so now you're in, or at least you're registered as an attorney before the immigration court bar. So what's going to happen next in your case? So usually the first thing that happens once you're in the case is that there is a master calendar hearing, and you're preparing for that. Things have changed up a little bit in the last year or so because the immigration courts have a new case flow processing memo. It was initially issued in November 2020, and then it was updated in April 2021, so it is still in place. And under this memo, the purpose is to try to resolve some aspects of the proceedings without needing to come into court on a master calendar or initial hearing. So in other words, the idea is that there might be a lot of the preliminary matters resolved through written pleadings, stipulations, joint motions, and the like. And so if that is true in your case, if there is agreement between the parties about the charges of removability and other basics of the case, then the court might go ahead and take all of that in written form and then set what we call an individual or merits hearing, which would be your final evidentiary hearing with testimony and the like. Even though this case flow processing memo sort of pushes towards not having master calendar hearings where possible, it really is still possible to get a master calendar hearing in your case if that's what you would like to have. And I'd be inclined to push towards having master calendar hearings in most cases, unless you really do think that you want to just get agreement on all of the initial stuff and get straight to the merits. But in so many cases, there are points of contention in relation to the charges or other initial matters, and you want to have a chance to be heard on those before going forward. Or sometimes you just need additional time to prepare and you want to go through the full process of having the initial hearings in court so that it's clear what issues are in play and so that you can adequately prepare for your case and give your client full due process. So if you do want a master calendar hearing, basically you can assert that request in your response to any written order from the judge under this case flow processing memo that asks you to do as much as possible in writing. You can say, okay, here's what I can do in writing, and I formally request a master calendar hearing. Another pretty surefire way to get a master calendar hearing, if you want one, is to contest the charges. And we'll talk a little bit more about what that means, but basically in almost every case, there's at least room to contest the basic charge of that the government has to make before anything else can happen of, has the government established alienage in your case? In other words, has the government established that this is not a U.S. citizen, this is somebody from somebody else who's properly subject to removal proceedings in the first place? So that's kind of the background on getting your master calendar hearing going. Speaking of that, Michelle, so assuming there is a master calendar hearing, or assuming that you're just sort of ready to get formally into the case, you're now e-registered and you're trying to get into the case and find out whether the judge is asking for written pleadings or is assuming there's going to be a master calendar hearing. What are those initial steps in getting ready for the master calendar hearing and finding out, kind of in your specific case, what the judge is asking for?
Yeah, sure. So the document that you want to file to enter your appearance formally in immigration court, it's called the EOIR 28. And so we often refer to this one as the E28 just for short. And that's a notice of entry of appearance as attorney or representative before the immigration court. And that is available online on the DOJ EOIR website, so you can pull that off there. And one recommendation that I have is that we complete these before we get to immigration court. That we, even though they might seem like very kind of pro forma kind of documents, it's going to require you to put in your EOIR ID number. It's going to require that you put in the client's current address and just things like that you don't want to just be doing at the last minute at the immigration court. It kind of also signals to the immigration court staff and the judge, if they see you, that you're kind of maybe not taking this seriously, you didn't take the time to prepare accordingly. So definitely do that before. That way, when you get to the immigration court, you're serene and you know that you've got all your paperwork ready and it's just a matter of the judge calling your case at that point. And this is not an EOIR document. This is not, again, a document that you would be filing with the immigration court. But we also suggest that for all cases, because all clients are susceptible to detention. I mean, hopefully they will not be, but just to be prepared, we suggest that you also execute with their signature a G28. And this is the entry of appearance for cases before USCIS or for which ICE has authority. And that will allow you to basically discuss your client's case with ICE if they were to get detained. If your client were to get detained, you can just not worry about having that document, or if ICE is giving you a hard time, oh, this isn't signed by your client, but it's like, well, how can I get access to my client? My client is detained, got moved to another state, all those hurdles that ICE puts before us, especially with detained cases. And if your client has changed their address, you want to ensure that, again, the client's address is current with the immigration court. So you're going to want to submit the form EOIR 33, also available online, that you have that ready to go. In the past or historically, this document is blue because it helps the immigration judge pick it out of a whole pile of white papers. And my understanding is, it's not a requirement, but it's still very helpful for the immigration judge for us to submit it in on blue paper if possible. And any types of pre-hearing motions, depending on your client's case, you're going to want to be ready to submit those perhaps at the master calendar hearing. You also, if you are ready to proceed with relief and you want to submit the application or part of the application, you don't have to submit the entire application. And we're going to discuss this in the subsequent 2 webinars. You have a call-up date and you should have more time to complete the filing and to add to the filing. But if you want to initially submit an application for relief at the master, you can go ahead and do so. Now, why would you want to do that? There are a couple of strategic reasons. One of them is that you have access, your client has access to a work authorization document, to an EAD, an employment authorization document. So that may be one reason. So we're gonna, talk about those applications for relief later on during this webinar. All right.
And Michelle, we've been talking about filing a lot of documents, starting with the entry of appearance and then other documents. Is there e-filing in immigration court? How does that work?
Yeah. So for the longest time, there was no such thing as e-filing in immigration court. So those of you who have practiced in Article 3 courts and state courts, you're probably like, how is that possible? But yes, that's the reality that we've been living in for quite some time. So until recently, there was no e-filing option. And now, as of recently, we have EOIR's Courts and Appeals System, which is called ECAS, yet another acronym for you guys to remember, which will become mandatory for new cases starting tomorrow on February 11th. And through the system, you're going to be able to enter your appearance in a case, file documents, review the record of proceedings. I just did that the other day and it was fabulous. And pay the BIA filing fees. Now I specify BIA filing fees, and this is also specified on the website as BIA filing fees. And you may be wondering, well, I know there's some immigration court fees that I have to pay. So why are those not included on ECAS? Why can't I pay those on ECAS? And really important tip, the fees for applications filed with the immigration court are actually paid to USCIS. Or alternatively, you can also do a motion for a fee waiver of the application fees to the immigration judge, but it's just like a quirky thing where DHS didn't exist before. So I won't get into that history, but just know that if it's a filing fee before the immigration judge, you're not going to be able to use ECAS because you're going to be paying that with USCIS. For example, a motion to reopen fee, that's going to be paid to any local USCIS office. And then service of all filings is accomplished through e-filing without a need to send paper copies to ICE. That is also our new reality. Note that EOIR held an information session just this week on Tuesday, on February 8th. So we'll be sharing notes of that session with all of you so you could see what's ahead with the ECAS system. All right. All right. So I know that my client's in removal proceedings. I prepared for the master calendar hearing. I know how to enter my appearance before the immigration judge. But I really want to be sure that I know how to prepare for this master calendar hearing and or for what Denise was talking to us about, which is the written pleadings. So how should I prepare for the master calendar hearing or for the written pleadings if there won't be a master calendar hearing?
Yeah, so the pleading stage is important. I think sometimes in immigration court, we're anxious to move past that stage and get to the asylum application or whatever else is happening. But it is really important to think through the pleading stage and to be extra clear, again, with all the acronyms for those who aren't regularly in immigration court. The notice to appear is a charging document. I know it sounds kind of like it's a hearing notice something, but it's really much more than that. It may or may not include really the notice of the hearing. It's really much more about the charges that are being filed. And so you want to be looking at that notice to appear very carefully before making pleadings, whether it's written or oral pleadings at a master calendar hearing. So the process might be a bit different about how you're submitting the pleadings, but the action of making sure that you decide strategically what your pleadings are going to be is pretty similar. You want to go over that notice to appear very carefully. And you want to look at each of the factual allegations very carefully and decide whether or not they are in fact correct. I mean, these can be things that are as minor but potentially important as when and how your client entered the country. And then you want to look at the charges of removability and decide whether they're correct as kind of a factual and legal matter. Can the charge actually be sustained as a matter of law? Because if not, then your client isn't removable, and that might open up all kinds of additional options. And so you want to be looking at that strategically. And then you want to be preparing the actual pleadings. There are templates in the Immigration Court Practice Manual, which is available on the Immigration Court website, that will help you do either the written pleadings or the oral pleadings. They go kind of walk you through each one of the answers that you need to provide to the court on that. You also do want to be thinking about, at this point, Michelle already mentioned it, the need to get FOIA. FOIA is the only way we get discovery, so to speak, in immigration court. And so if you want to find out what happened exactly in your case, to find out what the government has to say that the client entered on a particular day in a particular place, or what is supporting the charge, then FOIA may be the way to do it. So you may need a little bit of additional time to get records to be able to enter your pleadings in the case. Sometimes we can't let the court won't hold off on us as long as it takes to get the FOIA response back, but it is something to consider as to whether you want to get that full record before you enter pleadings in a case.
Great. All right. So what are the differences between preparing for the master calendar hearing and submitting the pleadings in writing?
Yeah, so basically there are separate sort of templates in the immigration court practice manual. I mean, there's a template for it all. And if you're doing it in writing, you want to go ahead and kind of answer each question in writing in a formal filing, which is required to follow all of the rules of the immigration court practice manual in terms of filings. So there's a specific cover sheet that you always have to provide in when you're submitting in immigration court. You need to, of course, have a proof of service, because you can't have any ex parte communications with the court. So you need to prepare the written pleadings per the template, and then make sure that the filing otherwise complies with the rules, and then either file that in hard copy format if it's an older case, because ECAS only has the new cases, as we've mentioned, and either do it in hard copy, or if it is a new ECAS electronic filing case, make a PDF of that filing of the written pleadings and upload it to the website. If it's oral, you're going to be walked through it at the master calendar hearing, and we're going to give you a bit of a sample of what that looks like. I would say, maybe the main difference in preparing for issuing or asserting pleadings at a live master calendar hearing is the need to prepare your client. So, of course, if you do written pleadings, you want the client to look over those 100%. But if you're doing it in court, you also want to prepare the client for what the hearing is going to look like, because this is probably their first hearing in immigration court, and likely their first hearing in any kind of court in many, many cases. So you want to let the client know who's going to be there, what's going to happen, what's the courtroom going to look like, what are you doing with the pleadings, and what's the purpose of the hearing, and all of that. And then you also probably want to let the client know that you as the attorney are going to be doing most of the talking, but that the judge might ask some basic questions like, where are you living? Are you so-and-so, the person that's referenced in this notice to appear? Do you understand your responsibilities in these proceedings? These are all questions that might be directed at the client. One last thing I usually try to let clients know about too is in connection with many applications that are filed, and also just sort of in general at the end of most master calendar hearings, the judge will give some advisals / warnings, which can be kind of scary about, if you don't appear for your next hearings, you're going to be deported in absentia. If you lie on any of your applications, you're going to be barred from any relief in the United States. And so you just want to let your clients know that that's part of what the law requires, and that you're going to help them comply with their obligations, but that is going to potentially sound a little bit scary when they're there at the hearing. My turn to ask questions. All right. So what if you do if any part of the factual allegations are incorrect? Like you're carefully going over the NTA and you see there is a problem.
Yeah, so hopefully everybody is doing this not just once, but a couple times, doing it with their client. But if any aspect of the factual allegations is incorrect, you're going to have to deny those allegations. Denial is really the only choice, because the NTA is not your document to, for example, try to amend And it's really awkward to start being like, let me explain to you, Judge, why this isn't right. You start off with just denying it, and you should not admit a factual allegation that is not 100% accurate, right? Like that is why you would be denying it. Again, not your document to amend, and you shouldn't be admitting to things that are not 100% accurate. And when you deny the factual allegation, that's going to shift the burden to DHS to present evidence in support of that allegation. And that's going to prompt the discussion where like the judge is going to then go to DHS, and DHS is going to say, well, this is what information we have. And it's a more natural sequence of events as opposed to you trying to say, hey, like, I don't know what to do here because this aspect is incorrect. Just deny and then go from there and let it kind of be an organic discussion. But again, should not be admitting to conceding anything that is not 100% accurate on the NTA.
And what about the charges of removability? What do I do if I want to deny the charges of removability?
Yeah, and you should be prepared to deny the charges if they are wrong or there's some doubt about them. And again, there's going to be some doubt because there might be some legal analysis that you are in the process of doing, and you think, for example, you know what, I don't think this is an aggravated felony, for example. So you should also deny the charges if you want to shift the burden of proof to DHS. So that's a reason why you would be denying those. That would again shift the burden to DHS. And you're going to want to oftentimes deny both the factual allegations and the charges to properly shift the burden and to be consistent. The burdens of proof actually are outlined on 8 CFR 1240.8. Yeah. So you want to go ahead and look at the regs constantly, right? So when we look at the regs, there's also a couple of other things that we'll mention at the end that you want to look at, but the burdens of proof are outlined in the regulations 1240.8. And DHS is going to always have that burden of proving alienage, what Denise mentioned earlier. So what is your origin, your country of origin, and are you a non-citizen? And if your client was lawfully admitted to the United States, DHS is also going to have the burden of proving deportability. So, for example, if you concede the charges, what you're doing is you're allowing DHS off the hook because they don't have to prove the charges at that point, right? So if you admit alienage, if you say, you know, my client is from Guatemala, and then you admit that they entered iwi, right? Then DHS, you've done DHS's job for them. And the reality is that some cases really are won because DHS does not meet its burden of proof. So for example, if you deny the factual allegations and the charges of removability, and the immigration judge shifts the burden of proof to DHS, but let's say that DHS at that master calendar hearing lacks the client's file. They don't have anything on the client, on the respondent for them, right? Your client, but the respondent for them. So what is going to happen there? They're not going to be able to meet their burden of proof. They're going to have nothing to show to the immigration judge when it comes to, for example, alienage. And they can present a couple of documents to try to meet their burden of proof to prove alienage. One of them is the I-213, for example. And what you would do there is that you would move to terminate the proceedings because DHS has not met their burden of proof. So that's why we say that, you know, some cases really are won in this burden shifting process. And I think, I don't know, Denise, if you agree, but I think the reality is that for a long time, for much too long, we've probably just done DHS's job for them without really thinking through, should I put the burden on DHS? So that's something for you to consider. And I just want to give a quick example because you might have dealt with this yourself at some point, but those of you who have challenged a speeding ticket in court, you're going to understand the process, right? Like if you showed up to court for your speeding ticket, you saw that the police officer was not there, they're absent. Well, what do? Hopefully you pled not guilty, right? Instead of guilty. So you see the police officers in there, you plead not guilty. And since there's no police officer to provide proof, you win. So those of us who have had speeding tickets in the past and have gone through this process, you will know that procedure. You will see the familiarity there as well. And just a very important note that if you are planning to seek a motion to suppress, if you're trying to do a motion to suppress, which we're not going to talk about during this webinar series, but you want to look into, then you must deny the allegations, you must deny the charges, or else you waive that strategy. So be sure to deny the allegations of fact, deny the charges, or else you're going to waive that potential motion to suppress opportunity. All right. And Denise, actually, I think we have a little bit of time, but would love your thoughts on what you think about the question that I had mentioned, or the issue that I had mentioned, that for too long that we had perhaps on autopilot been doing DHS's job for them by not appropriately shifting the burden. What do you think of that?
Right. Yeah, no, I agree. And there's some interesting chat happening. And I think there is still some discussion in the community. And I think the final answer, of course, depends on the individual case. And you need to talk about your strategy and think about it with your client before making a final decision. But I do think it's pretty clear that while there is absolutely an ethical duty of candor to the tribunal, which means that you may not misrepresent facts or even engage in omissions that are essentially misrepresentations to the tribunal, that's a very different thing from just denying factual allegations, particularly where the burden is on the government. And so it's really just more of a question of, as a matter of law, we are saying this is not established until it is established by some evidence. It's not making any misrepresentation that the person did not come in on April 3rd via Brownsville. It's just saying at this point, we're asking evidence to be presented. And so I think it's absolutely ethically proper, and it may even be ethically required in some cases. So that's my thinking on that. I'm in complete agreement. And I do want to note that a couple of comments in the chat also mentioned that it can just be a critical way to obtain documentation in your case that is critical documentation that the respondent needs to be able to have full due process and present their claim. And as I say, may not come quickly enough through FOIA. So sometimes by denying the allegations and the charges, you end up getting copies of the government's I-213, which is that document that's prepared at the time of the initial encounter between DHS and the respondent. And it's basically like a police report. You want to see the police report in your case before you proceed forward. So even if in the end, the judge ends up saying, okay, respectfully, counsel, I heard your denial, see DHS's evidence. I'm going to find that the factual allegations are established and the charge is established. Let's move on. You now have additional information that can help you in your representation. Yeah.
Absolutely. Yeah. Thank you so much. All right. So actually, I think we're back to the last question. We didn't actually ask that one. What if I'm not ready to enter pleadings? What do I do then?
Yeah, short answer on this one. You seek a continuance for attorney preparation time. That maybe is a written request for continuance well in advance of the hearing, or maybe you are entering an appearance very close in time to an initial master calendar hearing that's already set. And so you appear at the master calendar hearing and you advise the court that you need additional time. And almost every immigration judge will grant at least one continuance to allow you sufficient time to prepare your pleadings.
Great. And what will happen at the hearing besides taking pleadings?
Great question, and we'll do a little reenactment in a second if you like. But basically, in addition to taking pleadings, the judge will ask whether the respondent designates a country of removal should removal become necessary. Generally, in asylum cases, you want to decline to designate a country of removal. The court will ask if you have your applications ready. As Michelle mentioned, you might have it right there and be ready to go forward with filing of the application, or you may be telling the court that you need a couple of weeks to prepare any applications for relief, as we call them. So you'll have that discussion. And then the court will often ask you how long you need for the merits or individual hearing, like how much time do you need? Typically, judges set those for a couple of hours or a half day. So if you think you need a full day, you probably want to ask the court for it, and that's not an unreasonable request. You may or may not get it. And then there often are also discussions of interpretation needs. The court does provide the interpreter, but needs to know at the master calendar hearing what kind of interpreter is needed in a particular case, particularly if it's a more rare language, so that those arrangements can be made. And then there will often be discussion of any threshold legal issues, such as, basic eligibility for the form of relief that you've indicated you'll be seeking, or those kinds of things. I didn't say explicitly. You'll also be asked what forms of relief, if any, are you seeking, and you'll be asked to designate what those forms of relief, defenses against removal, are. Note that it's common for there to be a couple of different master calendar hearings in most cases. Not always. You can get around that if you're trying to move quickly in a lot of cases, but it's often the case that one is set as, continued for attorney prep time, then pleadings are taken, then applications are filed, and other arrangements are made for the final merits hearing. So that's pretty typical. And Michelle, is that changed up at all under the dedicated docket? What is the dedicated docket, and how does it affect our clients?
Yeah, so the dedicated docket applies in certain designated cities to families who arrived at the southwest border after May 28th, 2021, and were placed on alternatives to detention. The point of this docket is to move the cases very quickly, unfortunately. Usually requires a completion of within 300 days, which is, I said unfortunately before, because that's really quick. And anytime we're trying to move something along really quickly, especially in immigration court where there is no Sixth Amendment right to counsel, it's quite concerning. So it's too quickly to find counsel. It's too quickly to present claims effectively, whether represented or not. So especially since most asylum seekers are not going to have all the information that they need. I mean, they fled for their lives. They probably barely were able to take much with them, let alone thinking it like, let me think about this evidence or whatever. Like that just doesn't happen. That's not reality. So if your case is on this docket, what you may want to do is get it off the fast track, seek more time for attorney preparation, and then include some due process, fundamental fairness types of arguments as well. To show the judge like, hey, this is should not be speeding up this process, especially for such vulnerable people. Or if you feel like it's in the client's interest, as Denise said, everything is about the client's interest and strategically what fits that particular case, you may decide that, I got to move this case along more quickly, and that's what I'm going to do. So I just got a plan for that speed, basically.
Yeah, great. That's helpful. I want to note that a bunch of people have asked questions in the chat and Q&A about how to get an NTA filed. Should we take that up now, or should we leave that for a little bit? Maybe we can talk about that really quickly, and then we'll run through a little mini master calendar hearing. So there are. It is true, first of all, that often notices to appear are issued by DHS, sometimes even with a time and date on them for a supposed hearing in immigration court, and then they're not filed with the immigration court. And so you keep checking the system over and over. You've even called the court, and the court says, we don't have it. To be clear, sometimes the court has it and takes a long time to get it docketed. So you might want to start first with asking the court, do you have it? And is it just not getting set up yet? But lots of times DHS just doesn't actually file it with the court, which is the only way for the proceeding really to get started. So first thing to think about in trying to get it filed and get it going is, do you want to? You want to think first, is this really a case where my client would benefit from moving forward now, and moving forward in immigration court? Because there may be advantages to letting it sit for a while. Maybe the law has just taken a turn for the worse on something, and it may get better if you wait, or other reasons. And sometimes if the government doesn't file the NTA with the court, you may be able to proceed affirmatively in a case before USCIS. So you may not really be anxious to get the NTA filed with the court and get the case moving. But let's say you've decided that you are. A couple things. One is you can call up DHS, ICE, Office of Chief Counsel, and say, hey, you guys issued this NTA 6 months ago and it still hasn't been filed with the court. Can you get it filed? And sometimes that's all it takes is, some back and forth of urging them to go ahead and file it, that you're prepared to proceed, if they're prepared to proceed, and let's move forward. Sometimes even that doesn't work. And so another idea I have, and Michelle, you may have others, is that in some cases, what will get them to file it with the court is to go ahead and try to file an application affirmatively. So especially in the asylum context, where you can file affirmatively or defensively in court or before USCIS, if they're not filing it with the court, then you might try to go to the USCIS asylum office and get it filed. And maybe it'll work and you'll get to go forward affirmatively, which is great. Or maybe that will trigger finally the filing of the NTA with the immigration court and a chance to move forward in removal proceedings in immigration court. Do you have other ideas, Michelle?
Not necessarily ideas, but just kind of additional kind of tips to think about. That if your client came in fairly recently, so just note that that process of getting the NTA filed and for the court to docket the NTA, like you may want to give, I don't know, like if there's, a rule of thumb, but you may want to give some time in between when the client received the NTA for then DHS to file that with the immigration court for the immigration court to go ahead and docket it. So I don't know, maybe a month or a couple months. I don't know, Denise, if you have any time frame that you suggest, but before you go through the process of like, okay, let me go ahead and file with USCIS, because then, that might be futile, unfortunately. Now, if it's what Denise said, like 6 months, I feel like that's a failure to prosecute issue. And now that we have prosecutorial discretion back, one way that I would approach DHS would be like kind of, in a positive way, like, oh, it seems that you guys are exerting prosecutorial discretion in this case. You haven't filed this NTA, and I'd like to go ahead and file with USCIS. But I just wanted to confirm that you have decided that my client merits basically prosecutorial discretion. That's how I would probably approach it.
Yeah, I think those are helpful points as well. Great. Okay. So we thought we'd do a quick run through of a master calendar just to kind of give a visual of it. So I'll pretend to be a judge, which is an awkward role for me, and Michelle will be respondents counsel. So good morning, counsel. What case are you here on?
Good morning, Your Honor. I am here in the case of Mario Velasquez, A number 123456789.
All right. So I'm going to go on the record and state for the record that we are before the immigration court in the matter of A number 123456789. This is Judge Johnson with the San Antonio Immigration Court. This is a WebEx hearing today. Contract interpreter Jane Doe is also present via WebEx. Counsel, could you formally identify yourself for the record?
Yes, Your Honor. Michelle Mendez on behalf of the respondent, Mario Velasquez.
And is the respondent here with you today?
Yes, Your Honor. The respondent is sitting next to me to my right.
All right. And are you prepared to take pleadings today?
Yes, Your Honor.
One?
Yes, we do acknowledge service of the NTA dated May 29, 2021.
And do you waive the advisals that I would normally be required to give a pro se respondent?
Yes, Your Honor.
Is the name listed on the notice to appear correct with proper spelling?
Yes, Your Honor.
And how do you plead to the factual allegations?
Your Honor, the respondent denies all factual allegations.
All right, noted. How do you plead to the charge of inadmissibility under INA 212A6A?
Your Honor, the respondent denies the charge.
All right. So the government does bear the burden of establishing alienage in the first instance. I see that there's an I-213 submitted in this case with the notice to appear. There has been no objection to its admissibility, even though that was filed some time ago. So I'm going to go ahead and conclude today that the government has met its burden of establishing alienage and removability.
Uh-oh, I think we're having a little bit of trouble with Denise's internet.
Oh, sorry.
Oh, it's okay.
Am I back?
You're back now.
Okay. Did you hear me deny to find inadmissibility and removability?
Yes, Your Honor, we understood.
Okay.
Yep.
All right. And so what country do you designate should removal become necessary?
Your Honor, we decline to designate a country of removal.
All right. Under the authority of the statute, I designate Honduras as the country of removal. What relief, if any, is respondent seeking?
Your Honor, the respondent will be filing for asylum, withholding of removal, and protection under the Convention Against Torture.
All right, then. Do you have the I-589 ready?
Your Honor, we plan to submit the I-589 through ECAS through the portal today.
All right, then. And of course, DHS should then provide you with the biometrics instructions relating to that application as well. I'm going to go ahead and schedule an individual hearing at this time then. I'll swear the respondent to the I-589 application at the time of the individual hearing. And I'm going to go ahead and wait for the application as well. So I'll provide the respondent with the warnings regarding presentation of a frivolous asylum claim and the warning that that could lead to ineligibility for all immigration benefits in the future until the time of the individual hearing. How long do you expect to need for the individual hearing?
Your Honor, we expect to have expert witnesses and somewhat lengthy testimony, of course, through an interpreter. So we would request a full day for the hearing.
All right. Well, I tell you what, our dockets are very full. We have 1.5 million pending cases, so I'm disinclined to give you a full day, but I'll tell you what I can do. I'll give you an 8:30 a.m. time slot. I'll hope that we can finish by lunch, but if it becomes necessary to run into the afternoon, we can consider that at that time and consider rescheduling any afternoon hearings I might set. How about August 20th, 2022? Is that agreeable to all parties?
Yes, Your Honor.
All right. So that hearing date is set. We'll have an interpreter available in the Spanish language on that date, unless Respondents' Counsel indicates that no interpreter is needed in anticipation of the hearing. And respondent, you must appear on August 20th, 2022, or you may be removed in absentia. Anything further from either party?
No, Your Honor.
All right, then. This hearing is concluded. Yay. All right, great. Moving on from that, what should my client know about the WebEx format? We sort of treated that hearing as being on WebEx.
Yeah, so we're going to talk more about the WebEx format in subsequent, I guess, part 2 and part 3 of this webinar series. But thing to remember for the master calendar hearing, it's important for you guys as counsel, for those of you listening as counsel, to confer with your colleagues regarding recent experiences on WebEx, because that format is evolving. There's some, glitches, and judges are still getting used to it, and so it's just evolving, right? So just want to kind of give a caveat that it'll be important to check in with your colleagues who have done the WebEx format fairly recently to see how was it before this particular judge recently, and that'll give you some insight. But the client should know that, like an in-person master calendar hearing, there are going to be a lot of people there, right? So the master calendar hearing, sometimes clients don't know, oh my gosh, like there's all these people. I thought it was just my hearing that we were going to have today. So that's obviously something to explain for the in-person master calendar hearing. But similarly, in a WebEx hearing, that's going to involve other cases and not just their particular case. However, unlike an in-person master calendar hearing, where all the people there are going to be behind them, during the WebEx hearing, the client may see lots of faces on the screen staring back at them. That's what we've been hearing from the field, that there's just like a lot of people on at the same time. And so this can be confusing. It can cause the client to have a lot of anxiety. So counsel should think about, really putting themselves in the client's shoes and what they're seeing, and the anxiety and the confusion that may be caused by WebEx hearings. And that you're going to want to ensure that it's clear to the client who is the immigration judge. Hopefully the black robe will help, obviously, but nonetheless, who the immigration judge is, who DHS is, the interpreter, and any other court staff who are present there. All right. So Denise, tell us, now that we have kind of seen that mock hearing and we have talked in length about master calendar hearings, go ahead and tell us, what are some common forms of relief for which our clients may be eligible?
Yeah, great. Of course, this could be a whole semester long discussion of what forms of relief are eligible, but some things to be looking out for because you are going to need to identify the forms of relief that you're going to be applying for your client early on, because like we talked about, it will come up at the master calendar hearing, maybe even the initial master calendar hearing. So you need to be checking out the kind of substantive laws that applies to your case. So some common forms of relief sought in immigration court are asylum, withholding of removal, and Convention Against Torture protections, essentially refugee protections. And I should note, as we talk about these forms of relief, that some are available only in immigration court, some are available in immigration court or affirmatively with USCIS. Some require fees and some do not require fees. And so you need to be really aware of all of that as you're moving forward. So asylum, withholding removal, and Convention Against Torture protections are on the I-589. That's a free application. Basically, and it's much more complicated, of course, you're trying to show that your client meets the definition of a refugee, that they have a fear of return to their home country because they're likely to be persecuted based on a protected ground: race, religion, nationality, political opinion, membership in a particular social group. When you're filing an asylum application in immigration court, you may think about your strategy, and it may well be that it's best to file a pretty bare bones application, like just complete the 589, and then plan to supplement it with all of the evidence, lengthy client affidavit, other materials that you want to provide 15 days in advance of the merits hearing, because that's the normal filing deadline. So when you file an asylum application, you don't have to think, oh, at a master calendar hearing, I need to submit 100 pages of evidence and a lengthy client affidavit. It may be best not to do that, because then that kind of binds your client at an early date and your story may develop as you get ready for the hearing. Other forms of relief are adjustment of status, so applying for a lawful permanent resident card based on family ties or employment. That one does have a fee. You might be applying for non-lawful permanent resident cancellation of removal. That's for individuals who have long-standing ties in the United States who have ended up in removal proceedings, U.S. citizen or LPR, spouse or children, and many years in the United States. You might be applying for lawful permanent resident cancellation, which is for permanent residents, green card holders who've been here for lengthy periods, but who may have ended up in removal proceedings, likely because of some interaction with the criminal justice system. And there are other forms of relief, for example, under the Violence Against Women Act, that you might also be applying for in immigration court. So you want to be carefully considering all possible options. And you do want to keep in mind that it may be possible to apply for several different forms of relief in immigration court, and you may want to designate all of those. So we've mentioned that some of the applications do have a fee. Oh, and I should mention, so adjustment of status has a fee. Non-LPR and LPR cancellation applications do have fees associated with them. So you want to keep that in mind and give your client a heads up early on that they need to be gathering that money for a fee. And Michelle, so how do we pay the application fee? You mentioned that it's not really possible to do that through the court's filing system.
Yeah, so I mentioned that before. So the way that you would pay the application fee with USCIS is, first of all, you would go in person. There's not yet a way to do it online, but it's evolving in a good way. And so the first thing to remember is that you can pay an application fee in any USCIS local office. So it doesn't matter if your client is detained somewhere else. It doesn't matter if you happen to be on vacation in one state, but the immigration court is located in another state. You want to go ahead and file that fee. You can go ahead and do that at any USCIS office. So that's something to remember. You're not beholden to the local or your local to immigration court USCIS office. And now they have these kiosks where you can pay the filing fee. And so then I'm talking, and I should mention that I'm talking specifically about motions to reopen and motions to reconsider. Now that when it comes to the applications that Denise was talking about, the I-485, the application fee for cancellation of removal, you're going to get this biometrics information, the sheet that also has the filing fee instructions, and DHS is going to give that to you. You're going to send that in the mail. So it's really important to keep clear, what is the filing fee that I'm doing right now? Because what I was talking about with filing with USCIS locally, that's going to pertain to a motion to reopen fee or a motion to reconsider. That's filed with the immigration judge. But when it comes to these application fees, you're going to do it over mail. You're going to get this instruction sheet from DHS that it tells you where to send it, what couple of pages of that application to include. You don't include the whole application. It's just literally like a couple of pages of the application, and it's really straightforward. So I don't know, Denise, if you want to add anything else to paying the application fee with USCIS and some tips.
No, that's perfect. Thanks for explaining that. And what is DHS's role in removal proceedings?
So DHS's role, I mean, we all probably think that it should be to seek justice, to pursue justice. But the definition of justice often, unfortunately, depends on the presidential administration and power at the time. So, for example, prosecutorial discretion wasn't available under Trump. It was available under Obama. And it's now back under President Biden. That said, currently, our concerns are that, ICE isn't implementing the Biden administration's prosecutorial discretion guidance consistently or at all. And so that's a concern. But, that aside, when ICE OPLA, right, so these are the attorneys that we've been referring to DHS generally, but the aspect or the portion or the component of DHS that's actually in immigration court, those attorneys representing DHS, that's actually at ICE Office of Principal Legal Advisor, also referred to as ICE Office of Chief Counsel. When they exercise prosecutorial discretion, they're going to do so by stipulating to the elements of relief. Maybe they'll stipulate to all relief. They'll join in a motion to administratively close a case or to dismiss a case, so joint motion to dismiss a case, motion to reopen. They can also do a joint motion to reopen. I love motions to reopen, so that's why I keep bringing them up, and they're really important. But if ICE OPLA does not exercise prosecutorial discretion, then that means that ICE OPLA is going to advocate for removal for your client. Something else that they will do is that they will appeal the decision to the board if the immigration judge rules in your favor. So that's if they have chosen not to exercise prosecutorial discretion, or if there isn't any prosecutorial discretion opportunity at the time because of the presidential administration and power.
So I've had you talking for a while, Michelle, but I'm also going to ask you, so after the master calendar hearing, how do I start to plan for the individual hearing?
So planning for the individual hearing, you might get a hearing scheduled 2 years into the future. And you think, oh my gosh, I have all this time to prepare and plan, and I'm just going to wait this out. It's a mistake for a couple of reasons. One reason is that the court can advance that hearing at any time, and they do that. And then you're caught off guard because you haven't been diligently doing something on the case every month or so. And so you want to start preparing now, and you do not want to wait until the last minute. So that's like the number one rule of thumb, is like to start doing what you can now. We understand that you're not going to be able to do everything because you're going to have to find experts first, and you're going to have to get the expert declaration before you start drafting the brief. And there's just a lot of foundational components to tasks. And so, but you can write the outline of the brief, right? You can get that going. So this is what we mean about like doing what you can as you go. Drafting the affidavit, that's really just you and your client. So those are sessions that you and your client can start planning now. That's going to tell you if you start doing that process sooner. It's going to tell you if your client is potentially going to benefit from some therapy. And you want to get them into therapy and an evaluation and get that done sooner than later. That also takes a long time, not just the process of drafting the declarations, but also just finding the therapy support and some type of mental health evaluation that would be helpful for your client. Looking for experts, as I noted before, that you may want to look for an expert. Like, yes, a lot of asylum cases really just depend on an expert and their support of the case. So looking for experts takes time, and we're going to talk about that, I think, in part 2 of this 3-part webinar series. But finding an expert, getting them to draft a declaration, learning about the country from them if it's a country type of expert case, and they have a lot to teach you, basically. So that process takes a while. And you want to familiarize yourself with EOIR policy memoranda in addition to the law and the regs. So for example, Denise had mentioned I think the policy memo on pro bono representation, which applies to all of you, right? Or most of you. So we'll take a look at that policy memorandum on pro bono representation issued by EOIR. There's also another one about what to do if the immigration judge goes off the record, which is really important, but not as well known. So there's a lot of really good information in those policy memoranda, also known as OPPM. Don't ask why the name has changed. Also requires a little bit of history. Not worth it for you guys. But what else do you think, Denise, that folks can be doing to plan?
No, that's great. I do want to absolutely highlight the pro bono memo because we were without one for a few years, and since a lot of those on this particular webinar are likely to be providing pro bono representation, it's really good news that the courts are being instructed to make accommodations to attorneys acting in that pro bono capacity, and you should feel confident in bringing forward that memo. It has good language about accommodating schedules and other important aspects of accommodating pro bono attorneys. So yeah, so now, well, we wanted to leave a few minutes for questions. So I think this has all been really, really productive. I wanted to note for everybody here that we made a real effort to use open-ended questions for the most part throughout this proceeding. And so that was intentional too, and is something that you might want to be working on early on as you prepare for your merits hearing, your individual hearing, because that will be the format of your direct examination, which will be the main form of testimony that you'll be taking up because it's unlikely that DHS will offer witnesses that you'll be cross-examining. So you'll mainly be engaged in direct examination of your client and potentially expert witnesses as well. So you want to work on that. But otherwise, I think it was a really helpful conversation today. Michelle, did you have any last comments to add?
I don't think so. I think we have a few questions instead that would probably be good use of our time to answer. Yeah.
Yeah. Did you have any in particular that you wanted to take up, Michelle?
Yeah, let me see.
Sorry, and while you guys are perusing the questions, this is Stephanie Baez again. I'm just going to pop in and give a plug to everyone for participating in pro bono projects. Pro bono representation is a great way to use the skills that you've learned during this training or that you're learning as you're becoming a more experienced immigration practitioner. So if you'd like to do pro bono work with the ABA Commission on Immigration, there's a QR code here that you can scan and complete a volunteer interest survey. Or there's a link that's here in the slides, and it's also has been shared in the chat, and I think someone can share it again in just a moment. So please feel free to fill out a volunteer interest survey just to express interest, and we can try to connect you with a pro bono opportunity or tell you more about how you can use these skills. And now we can turn to back to the questions and answers. And just to kick it off, because I've been trying to categorize some of them for our speakers, so you don't have to read through everything. Thanks everyone for the very active Q&A. We've had a couple of questions on interpreters. For example, do we request an interpreter for the master calendar hearing? If so, who pays for the interpreter? What's the process? And what's the process on WebEx for having interpreters be there? And then along with that, if an interpreter, that people have noticed that there's been interpreters that don't interpret everything, like the exchange of dialogue in an MCH, and how should that be handled?
Right. Yeah. No, this is a long-standing kind of set of questions. So first of all, interpretation in immigration court proceedings is 100% provided by the court. In fact, you are not allowed to provide your own interpreter or to pay for your own interpreter. You could have an interpreter on your team who's kind of letting you know if there are problems with the interpretation, but the interpreter is absolutely provided by the court. And that is both for the master calendar hearing and for the merits hearing. How does the court know which language? Honestly, a lot of times it is a bit of guesswork until the respondent appears for that first master calendar hearing and the judge has the opportunity to ask. Spanish is, the one that they often have just kind of as a standby. There's usually a Spanish language interpreter available. But for example, if the judge sees that it's a case from Democratic Republic of Congo, they may sort of guess that they may need a Lingala interpreter available and then wait and see what the client says when they have them in front of them. Often for those less commonly appearing languages, the court will call in a telephonic interpreter. That was true even pre-WebEx days. That those interpreters would usually be over the phone. In terms of whether the entire master calendar hearing is interpreted, that's a really important and good question. And truth is that it doesn't just vary by judge, which I have seen that, but it also varies by policy time period. So there have been times when there's been clear guidance that absolutely everything must be interpreted, and then that guidance will get taken back, and then it'll come back again. And so you do want to sort of check to see what current guidance is. And if it is to provide full interpretation, rely on that. And if that isn't the current guidance, then if you believe it's important for interpretation to be complete, which I would say it is always, then you may have to ask for that. I think that's the best summary of it.
Yeah, and I would just note that, there are interpretation issues that arise. I mean, it could definitely infringe upon the 240B4B rights that your client has. So under INA 240B4B, that's my favorite provision of the INA because it outlines that your client has a right to present the case and present evidence and to review evidence against them. So take a look at that and take a look at how the interpretation may be infringing those rights. And there's a Third Circuit case that came out fairly recently, BC. I can't remember what the second portion is, but BC maybe Attorney General, I think might be the name of the Third Circuit case, which is really great case. There's a bunch of questions about denying the factual allegations and the charges. And I mean, there's just so many of them. I don't know, Stephanie, if you kind of gathered what the common theme was regarding those questions.
Yeah, I think it's a great point. There were a lot of questions on that. And mainly we've seen a lot of people ask, do you need a basis to deny the factual charges or grounds of admissibility? And do you risk making the judge mad? There were a lot of questions about judicial pushback if you are refusing to designate a country or denying charges. And then another question in that category is if you come on as an attorney later in a case where either a pro se respondent or with prior counsel, someone is incorrectly admitted to charges, is there a way to backtrack and how would you handle that?
Oh my gosh, yeah. So, I mean, what is the reason that it's not your burden to prove, that it's DHS's burden? Like, you don't really need another reason for that. Now, is the judge going to get mad? Maybe, but then it's like, so what, right? I mean, yeah, of course, like you want to be on the judge's good side. We get that, but it's more important to build the right record for your client and to put them on the best ground strategically, if that's what the client's case really requires. So I wouldn't worry so much about the immigration judge. And I will say that part of the reason the judge might get mad or might get turned off or be surprised is because, again, we've been kind of on autopilot for so long on this instead of really thinking through, like, do I want to just shift the burden to DHS? Like, is it time that we started doing that more intentionally in these cases and getting judges acquainted and used to us doing that? Part of why they get annoyed or mad or whatever is because they're used to us just like doing DHS's job for them. And as Denise said very, very well, it's not an ethical issue. It's just about burdens of proof. So I feel very strongly about this particular issue. And so that would be my point on that. I can't remember, Stephanie, what your third, I think there was like a last question there.
Yeah, the last part of it was if prior counsel or pro se respondent has incorrectly admitted to facts or charges, how do you handle that?
It's really hard to get the prior pleadings withdrawn, which is another reason that you don't want to do it incorrectly. For motions to suppress, you would if you're going through that strategy and it was done incorrectly previously by another attorney, you're looking into ineffective assistance to counsel claims at that point. But that in itself might not necessarily even help you with suppression, because it's kind of like the cat's out of the bag, the cat's kind of out of the bag. So it's really tricky. Denise, what do you think?
Yeah, I agree. That's why it's so important. There are times when you can make arguments, everything relating from, sort of ineffective assistance of counsel to coercion, if a client was detained and there were particular elements, if the client was being forced to plead quickly in order to try to get out of detention. So there might be avenues that you'd have to explore, but it really depends on the individual case, and definitely much more challenging. Again, I mean, I think on all of this, the key issue is you need to look at your case and decide what's the very best strategy in your individual case. But I also agree with Michelle that it'd be really helpful to look again at that regulation on the burdens of proof. It's stronger than you think. I mean, I just recently looked at it because we did this in a case, and it's true, the judge was not used to it. But then if you say it calmly and cite to the regulation, they are lawyers and they're expecting you to be lawyers too.
Yeah,
well, with
absolutely.
that, I think unfortunately we've reached our time limit. This has been such an informative panel, and we really appreciate both of your time and expertise. I know that there are a number of questions that we weren't able to get to today. Our team will download the questions and do our best to provide written answers after the fact as well. Please bear with us. It might take some time to get those answers together for you. But we'll also be circulating a recording of this webinar, as well as a download PDF of the questions and answers that have already been answered. So we thank you all for your engagement and the active chat and Q&A. And like I said, we'll be taking a look at these questions and seeing what answers we can provide to you in the future. So thank you everyone for joining, and we hope to see you at parts 2 and 3, which are coming up in the future. Thanks very much, Michelle and Denise. This was such a wonderful panel.